Today on Hashtag Lawyer, we have our friend Ryan Segall here to talk about the Jerry Springer world of custody battles. He's going to talk to you about the important things you need to know, and we're going to get some pop culture analysis as well. Welcome back to Hashtag Lawyer, you guys. We're going to talk about family law today.
Family law.
And, it's funny. Most people assume that criminal defense cases and criminal defense lawyers have the best stories. And there's a lot of good ones, but the drama is always in family law.
The family law.
My best stories come from there, and I'm really excited. We've got our buddy Ryan Segall here today.
Absolutely.
Because he's got some phenomenal stories that I've been a part of a few of them, and then we've also just heard them through the years of getting to know him.
I know, I forgot you guys were opposing counsel on a case when I lined Ryan up.
Right. Well, I guess, Ryan, I wasn't too much of a jerk on the other side of that case we had together, was I?
Don't feel free.
Feel free. I had a great time beating up on you in there. So.
Exactly. Well, Ryan, I want to let you introduce yourself, but I do want to tell our audience that Ryan is board certified in family law in Texas. And just to put that in perspective, there are only 835 lawyers that are board certified in family law in the state of Texas, out of the thousands and thousands of active lawyers that practice right now in that arena. And so it's a really huge honor. It's a big deal that Ryan's board certified. And so first off, congratulations on that, Ryan.
Thank you, sir. I appreciate it. Yeah, I know they're taking the test, I think in a few weeks or so for the next round of people, but they keep delaying it. So right now I've got this, I'm still the last class to have it.
Yeah, you got the shine going.
Right.
Well, and Ryan works at Walters Gilbreth. And tell us a little bit, how did you end up in family law?
So, when I went to law school, I aspired to be a divorce lawyer. I think that's what everyone does, right? No? Is that not the
That's
case?
what inspired me to go to law school. Forget To Kill a Mockingbird.
Right. So, no, when I was in law school, I interned at the Kong DA's office and realized I liked trial work. And it was something that I wanted to get into. My next summer, my 2L summer, I worked at a family law firm. That was my first experience in family law. And I realized I liked it a lot. There was two ways to get into the courtroom a lot. And it was either criminal defense or prosecution or family law. And I enjoyed family law. I thought I liked the drama aspect of it. It fit my personality. If I can watch reality TV and essentially get paid for it, I'm in. So that's how I ended up in family law. Being in the courtroom all the time, it's something that is one of my favorite things of family law. So that's what I do.
You actually get to play a role in the reality TV show that you're participating
in.
That's
right.
Let's be real. One of my dreams in life was to make a cameo in Keeping Up with the Kardashians, but since this is their last season, apparently that's not going to happen. I got close once, though, kind of, sort of.
Wait, what?
Yeah, so I was going to talk about this in our next episode.
Okay, that's fine. We'll save it.
Okay, well, ask me.
So you got to tune in next week, I guess.
Yeah, tune in next week for how I almost kind of sort of made a cameo in the Kardashian world.
It's going to be news for me too, actually. Well, Ryan, we use this term family law. We throw it around all the time. Can you tell our listeners what are some different categories of the cases that fall under this family law umbrella?
Sure. So family law, I tell people if it has to deal with a spouse, an ex-spouse, or a kid, that's pretty much what family law is going to entail. So we deal with divorces, we deal with custody issues, we deal with enforcing your orders, termination lawsuits, when one party is attempting to terminate the other party's parental rights. There's all sorts of different types of cases that fall under the guise of family law. But the basics is if it has to deal with a kid or a spouse, that's what we deal with.
And there's a lot of times that we see some of these different areas you're talking about, they end up overlapping, or you'll see the same two different areas in one specific lawsuit, and they're kind of interrelated, right?
Right. So typically you'll have, in a divorce, you'll have, technically there's two different lawsuits. There's the dissolution lawsuit, which is the property aspect of things, And then there's the suit affecting parent-child relationship. We call it a SAPSR for short. And that SAPSR and the dissolution suit are combined into the same divorce proceeding.
Good.
So then when you have these two different proceedings, the proceedings with the children, you know, maybe in 5 years, say Jane and Jimmy are married, they're in love, yay, and then they decide they hate each other 5 years later. Or maybe Jimmy pulls a Caitlyn Jenner and is like, I'm actually a woman, so I got to get divorced because I'm just not into being a man anymore. That's cool. You know, you do you, bro. So they decide to get a divorce. And this is a really long hypo. Sorry, guys.
Keep it going.
They're happy. They get their divorce. They're like, oh, it's a conscious uncoupling, kind of like, who was the guy on Magic Mike?
I didn't see that.
I don't
movie.
know why I'm looking at you.
Come on. Probably don't look at Ryan either. I'm just saying.
Sorry, bud. Anyway, so great divorce, whatever, easy custody battle for the kids. But then 2 years later, Jimmy's like, hold on, I'm a way better mom than Jane is. I should have 100% custody of the kids because Jane won't let the girls get nose jobs. That's like abuse. So I should have full custody. What is Jimmy / Jeanette going to do then, right? Because, you know, the divorce has already happened, but now he wants to modify the pre-existing child custody arrangement. So how does that happen? How does Jimmy / Jeanette make it happen?
And you just used the term that it's called, a modification lawsuit. So in a modification lawsuit, you're trying to change what happened in that prior court order. You can't do it for property issues, but you can do it for child issues. So, you know, and it can range it can be a full range of things, from whether it be from changing child support, changing who the child lives with primarily, changing your access and possession times, you name it. If you want to change it, a modification suit is how you do it.
And you know, when we use the term custody battle, that's usually the term I use. I mean, that's the form we're talking about, right? Is that we're talking about a modification suit because of all the different issues that you were talking about there. And so, Ryan, you know, we always try to talk to our listeners and give them some takeaways from here. And so I'd kind of want to dive in and talk to you about what are some of the biggest focal points or things that our listeners should know about custody battles.
Like a top 3.
So you gave me some homework, and I did my homework here. The top 3 things that number one, that I tell every client is document everything, no matter what it is. Just make sure that you're documenting it, because if you're not, it's going to be incredibly difficult for the court to say, okay, well, we believe you. And then the other side's going to say, Your Honor, don't believe them. They have no idea what they're talking about. But if you have the documents to back it up, then you're good to go. And when I'm talking about documenting, I'm talking about putting things in writing. So text messages. Be on your best behavior. You know, I can't imagine the number of times where people have just put things in social media or text messages, and I think to myself, what are you really putting that in writing? But it goes both ways. So if the other side keeps calling you, you know, FUB and all this stuff, you've got the text messages to prove it. Keep those text messages, because it makes my job a lot easier when I can say, Judge, here's what's happening. Look at all these text messages for over the past year where this person is withholding the child, or this person is doing, is just dropping the child off with somebody else. All those things, if you can document it, then it's going to make your case and your lawyer's job a lot easier.
So I have a question for you. What is probably the craziest thing that you have seen a client do a good job of documenting?
So, and I don't want to get into too much detail.
Yeah, no, not too much detail.
So there was a case in which the other side had, this wasn't my client, but the other side had essentially put into writing that she was attempting to buy poison for a very, very large animal. I think it was an ox or something like that.
An ox.
And later, my client had become hospitalized with some sort of
nice.
So yeah, that was and all those were on social media messages.
On social media messages.
Wow.
Yeah, private messages between the other side and some other guy.
Going down the DMs. Nice.
Right?
Nice.
Okay, and I'm glad that you brought that up. So let's dispel this myth and this rumor. I hear it all the time from a lot of my friends, and they're like, no, I was DMing with my best friend. Like, that's private. Those are private messages. I have a right to privacy. No one can see those messages. Can you please dispel that rumor?
Yes, that is not true at all. No. I mean, I will tell you this, in that there is a lot less privacy than you think out there when it comes to messages of that nature. It is much easier to get those sort of messages in a divorce lawsuit than a modification lawsuit. I think in a modification lawsuit, you could make the argument messages between, myself and my best friend, you can probably make the argument that those aren't relevant and that the other side shouldn't be able to get them. Mm-hmm. If you're talking about in a divorce lawsuit, though, it's a little different because you're dealing with potential adultery and things of that nature. So there's more of a chance to be able to get all those messages. Another thing, when you're talking about expectation of privacy, that I tell clients, be careful when you're seeing, psychologists, therapists, things of that nature, because you're able to get the, as an attorney on the other side, I'm able to make any sort of argument that those could be relevant, then I'm going to be able to get those notes from your therapist, which a lot of people think, oh, I'm telling my therapist, there's privilege here. Well, but if there's a custody battle, there's exceptions to that. So.
Yeah.
That's wild.
Well, and it's because that whole best interest of the child thing. And so, for our listeners, a lot of discovery when like a civil lawsuit is very limited, there's certain issues trying to look at. Well, kind of like Ryan was just saying, the family law is kind of wide open. And I've got to follow up. So I've got a social media story that one of my favorites ever. Ryan, you were talking about documenting. And one of the big issues we see a lot of times is one of the parents is saying, well, the other parent is not exercising their time with the children. They are pushing them off on other people, they're whatever. I had one mom who was adamant that she was out of town on these work trips and that was why, and she was trying to make the blame that because our guy, our dad client couldn't make arrangements, that he was being a bad father, all this kind of stuff. Well, and she had a private Facebook. So this is another thing. But we figured out some people who knew some people who knew some people who knew her. And this one huge work trip that was so important for her career, she had Cancun Facebook pictures up there.
Oh my gosh.
A lot of sex toys involved.
Oh,
a lot of
on the
half
pictures.
Nude in the pictures. And so one of my favorite
on Facebook, on Facebook, just plastered everywhere on this weekend.
What the frick?
And so a lot of my friends know this. I love introducing embarrassing pictures into evidence because it's just kind of fun to go through and do that, especially when the other person's lying. So had a lot of fun with that. That's probably one of my crazier, I said I was here, but I wasn't here stories.
Man, that's wild.
I've got one more social media one.
Yes, please.
So.
We like things in threes.
So I had a case in which, it was a crazy case, and the dad was claiming that he had no income. He was basically saying, he told the court that he couldn't pay his court costs because they were a couple $100. So he was asking for the court to find him indigent. Well, we get to court and we have his social media, which was public, and he had a aspiring rap career. And on his social media, he just had these pictures of stacks and stacks of money.
Oh,
so
my
one of them was him in the back of his. He worked at like a convenience store or something. And there was a picture of him surrounded by stacks of money in the convenience store. There was another picture of him literally on a grill, where you like grill meat and stuff like that. There's a picture of him basically flipping stacks of money, like he was grilling the stacks of money.
How do people come up with this stuff?
The court found that he was not indigent.
Did he try to claim it was fake money?
Well, what he tried to claim, so his argument was that the outside of the stacks was a 20, but everything inside the stacks was only 1.
It was only one.
It's creative.
Right.
I know where he's using those ones.
It wasn't bad. It wasn't bad.
That's funny.
Creative. Points for creativity.
Well, Ryan, moving into the next, you talked about documenting everything. What's another point that you think our listeners need to take away?
Number 2.
So when we're talking about modifications, here's the biggest one is make sure you understand what you're signing. So if you enter into an agreement, so you can go to mediation or just agreements between you and the other side, make sure you understand what you are signing. The amount of cases that I have taken that we've had to change and modify the order because someone said, well, I didn't understand it, or my attorney didn't explain it well, or, whatever. It's going to cost you a bunch more money than it would to get it right in the first place. And make sure that you understand what you are signing when you have these agreements. One example is what's called a geographic restriction. And a lot of people don't know this, and this is something that comes up a lot. In Texas, there is essentially the general concept is that the court is going to try to keep parents together. And to do that, the court is going to restrict where a child can reside. Now,
you mean together like geographically, keep them in the same area, right?
Right. So in other words, if there is, let's say mom has primary, the court is going to say, Mom, you can designate the primary residence of this child within Dallas County and what's called contiguous counties, which is touching counties to Dallas. So, Tarrant, Denton, things of that nature. If that restriction isn't in there, then mom can just move out to Alaska if she wants, and there's nothing the other side can do about it. Now, conversely, if mom agrees to that and she wants to move to, say, California because of a new job or something, she's going to have to show the court why she should be able to move there. So I've had cases in which people did it themselves as far as a final order. No one checked the box on geographic restriction. The other side says, hey, I'm going to move up to Michigan. Well, my client comes in, hires me. I've got to run down to the courthouse and explain to the court why the court needs to put a geographic restriction in, and that bar is much higher in those modification lawsuits. So make sure you understand your order, because if you don't and you don't like it, it's going to be much more expensive and harder to fix down the road.
Just another example of hire a lawyer, don't do it yourself.
Yeah, absolutely. Well, and Ryan, I think one key point, you said it at the very end there, but we don't have to get all in the weeds on the legal terminology of it, but one of the things that's really important to understand is, can you explain to our listeners how or why it's much harder to change something that was already in a previous order in a modification suit, like the legal standard, why there's a bigger hurdle to get over?
Of course. So in a modification lawsuit, the bar to change it is what's called a material and substantial change, a material change in circumstance. And the courts have touched on this before, but there's no, hard and fast line as to what that means. It can be anything. So I tell clients it could be a change in income. It could be another person moving in. So let's say dad all of a sudden starts dating someone with a laundry list of felonies and drugs and things like that. That could be a material change. It can really range. It's a giant range that there is no definition as to what exactly it is. But that is your standard, and it is the burden on on whoever's trying to change the order. That burden is on that person to prove that there's been a material and substantial change.
Yeah. And so, I mean, and that's what I try to tell clients all the time is it's got to be something big. You can't, or something that's at least precise that you can point to. If you're just pissed off because you're pissed off, you're honestly going to spend a lot of money for no reason on that, because if there's not something that's actually changing the well-being of the child.
So if Jimmy/Jeanette comes to you and says, oh my gosh, Jane won't let the girls get nose jobs. They're 16 and they need them. They're going to be ridiculed at school, and we need to change this because this is fundamentally horrifying to them if they can't get a nose job. Is that going to be a material and substantial change?
Probably not. But, I mean, you can make the argument, you can make that argument and say, well, hey, there is, I mean, heck, I've seen a whole bunch of arguments made that are truly mind-blowing sometimes. Well, you know, the person is now a few years older, so that's material substantial change. That is not a change. And generally the court looks to, was this change anticipated in the old order? So in other words, if I think there's a case recently that came out that says if you are, it had to do with passports or something like that. And basically the other side says, well, I want to get a passport now. And they said, well, that was something that you should have addressed before because you knew that was going to come up. So there's all sorts of different things. And, you know, like you said, talk with an attorney, because an attorney is going to be able to say, hey, that is a material substantial change, or that is not a material substantial change. Don't waste your time and money. But, I mean, you can make the argument. You can say this is affecting her well-being because she can't get a nose job because of the bullying that she gets at school and this and that. I mean, it's probably not going to fly, but you never know.
You never know. I mean, maybe her budding career as a model is going to be forever ruined, because now instead of cute, adorable little kid modeling, she's trying to do like the kids that are post-Disney Club, like Britney Spears transition modeling.
See, it sounds like you would be the one to make this argument.
I would be.
We'd probably bring you in as a relief pitcher to come in and try to make this argument.
Sign me up. Although, full disclosure, ladies, embrace your natural noses. They're great, unless it's actually like a deviated septum and like causing health problems. So, but you do you, boo boo, like you know, all that jazz.
Well, and I mean, Ryan, being able to talk about whether the nose job is a material and substantial change, and being able to do that on the front end. I mean, I think this is a little plug here that we do this from time to time, but that's the reason some people need to come talk to someone like you who's got the experience, because in my experience with modifications, because you can do this multiple times over the child's life before they turn 18, and because usually couples that get pissed off at each other continue to get pissed off at each other at other places, those can be sometimes 2 or 3, 4 times more expensive than maybe the original divorce was, right?
Not only that, but they can be, but the issue with the modification is that in a divorce lawsuit, you know, Texas is a community property state, and I won't get into too much of property issues, but community property state, so all the income during a divorce is community income, meaning if dad is making $500,000 a year and mom is a stay-at-home mom, well, guess what? That $500,000 a year is going to be essentially up for division, and mom's going to be able to get some of her attorney's fees paid.
Right.
Different scenario in a modification lawsuit, because in a modification lawsuit, it's more or less every man for himself. You can get attorney's fees awarded. However, there is a higher bar, especially when it comes to interim attorney's fees, in which you have to prove safety and welfare issues for the children, and that's why you have to prove that to get your attorney's fees paid for at that point. So that's why I always tell clients, put it all in that first order, because if you don't put it in that first order and you're trying to change it later on, it could be much more expensive.
For sure.
And you're on your own.
Right. No, that's a very good point. That's a great point. So moving into our third point, Ryan, what's the third point you want to talk about with our listeners?
So keep your emotions in check. I mean, it is part of my job. I understand I signed up for this job, so it is part of my role to be kind of a counselor to these individuals. And heck, if you're going to pay me at my hourly rate, I'm happy to sit there and listen to you. But everyone needs to keep their emotions in check and act reasonably and try to put the kids first. I mean, that's really what you should be doing, because no matter how much of an asshole that dad is, because dad is sleeping with half of the Metroplex, it doesn't matter, because it's about your kids, and you need to separate those two things, because, and I've had judges tell my clients or tell opposing parties, you know what, this guy's a terrible husband, but he's a good dad. And you need to remember that when you're going through these cases, because don't hurt the kids because the other side wasn't a good husband or wife. I mean, that's just how the case is going to play out. And if you come into court and you look as like a spiteful individual that is harboring resentment because of things that happen in y'all's relationship, whether it be at that time, whether it be 6 months, whether it be 2 years, whatever, you don't want to have those resentments come through to your kids, because the court's going to tell every one of you that the kids are going to be able to tell when there's tension between you and dad or you and mom.
Mm-hmm.
So
100%.
Yeah, absolutely.
You need to be realistic about what you're putting these kids through, and talk with attorneys about it. But you may want to talk with, if you still have some issues about things that have happened in the past, talk with a counselor. Just tell them not to write things down, because
don't write it down.
Well, and that's a great point. I mean,
Yeah.
One of the lawyers in my office, Skylar, says it all the time to our clients, that kids are smarter than you think. They can pick up on these things, like Ryan, like you were just saying. They pick up on this tension. They pick up on what's going on, and that kind of segues into something a little bit more serious. And this is something we talked about, was that this term abuse is thrown around a lot. And I'd like for you to kind of talk with, because you talked a little bit on the pre-show call about some of the allegations that get thrown out there that are a little ridiculous.
Sure. So something that I hear all the time, and in my brief stint practicing family law, and now some of my friends who practice, I hear their stories. I hear the term abuse thrown around a lot. And I also hear the term verbal abuse thrown around a lot. And, I just think it's really important for our listeners to understand what abuse actually entails, because I think abuse is actually a pretty high bar. And if you're going around making allegations of child abuse, that can come back and bite you pretty hard. Yeah. So, Ryan, why don't you kind of dispel what the standards for abuse actually are, and then what is verbal abuse? Does verbal abuse actually do anything in a modification suit? Like, break it down.
Well, not only in a modification suit, but in original suits as well. I mean, whether there's abuse being claimed in an original lawsuit, whether it's a modification suit, you need to remember this, is that these courts see the worst of people, every one of them. And these judges in family law, they see some pretty horrific things. And when you're talking about abuse, for you guys, for a husband and wife to have an argument, it's not going to be abuse. And the court's not going to say, hey, dad, you're now primary caretaker of this child because mom yelled at you once. It's not going to happen. And I tell clients, you need to, again, document it. And if there are issues of abuse that is a serious thing, call the police. Because I'll have clients that come in and say, he abused me. He abused our kids, this and that. Well, did you call the police? That's question number one, is going to be, did you call the police? And if you didn't call the police, or you didn't take your child away and take him or her to safety, there's going to be some questions. Why didn't you do that? I mean, the number of clients that I've had that have told me, well, she abused me or he abused me. Well, guess what? If you don't have any proof, and if that happened 2 years ago and you've allowed him or her to have the child overnight for weeks at a time, no one's going to buy your abuse argument if there's no proof of it. And one thing I tell clients, and I don't want to give away too many of my secrets here, but one thing I tell clients is, have a recorder. If there's abuses happening and you are still living in the same house, and this is obviously more applicable to SAPSers and original lawsuits, but if y'all are living in the same house, get a recorder or turn your phone on, record these things. Texas is what's called a one-party consent state. So in other words, as long as someone that is party to a conversation is recording, that's okay. And that is admissible in court. And so if there is verbal abuse happening, record it. You don't need to let the other side know. You can do it. Like I said, you can do it on your phone. You can have a recorder, whatever. But making sure that it is documented so that you can come into court and say, Judge, listen to what he's doing, and then you can start turning some heads, and you may get some rulings to come your way based on that abuse.
So let me give you a hypothetical. If you have Jean, and Jean's a former VS supermodel, made more than Giselle and Kendall Jenner combined, like supermodel to the max. She marries David. They have baby girl Tiana, and Tiana is 14, and Jean's like, this is time for Tiana to break into the modeling world because she's a mini Jean and beautiful. And dad now has a habit of coming home and having like a 2-martini dinner every night, and then he'll say in front of Tiana to Jean, he's like, oh, you're such a dumb bee. All you do is sit at home and spend my money on Manolo Blahniks. I hate you. And this goes on for 2 years, but he never, touches Jean. He never touches, Tiana. He says these very hurtful things to her. And then he says, I can't support Tiana going into modeling because she'll be a dumb bee just like you, Jean. Is that going to constitute verbal abuse? Is that something that the court will take into consideration? What are your thoughts on that?
I don't think that's going to make a whole lot of difference. I think the court is going to look towards whether or not these things were occurring in front of the child. That's going to be a big aspect of it. It is, if I forget, is it Jean, and who is the husband in that scenario?
David.
David, okay. Tiana was the only one I remembered.
Because she's got a cool name.
So, a beautiful name. My gosh. So if all of this is happening between the two of them, and Tiana has gone to bed or something like that, the court's going to frown upon it. But are they going to take away David's time for it? No. Again, it goes to, this guy may not be a great husband, but that doesn't have anything to do with how good of a father he is. So, everyone needs to look at it that way. Is how is this affecting the child? Is the verbal abuse of him saying, you wasted all my money? Every client of mine says that. Every one of them. And then I have to explain to them, Texas is a community property state. What's his is yours. What's mine is his, and what's his is mine. It's same thing. And here's the other thing. On the flip side, if it's the breadwinner, whether it's the wife or the husband who's bringing in that money, well, guess what? Y'all let the other side just spend it. And if you go for 2 years with letting them just spend the money, guess what? That's on you too. Yeah. So, it's a two-way street, and that's something that oftentimes gets forgotten.
Yeah, absolutely.
So,
well, I was going to say at this point, let's take some of this stuff. I'd like to apply it to the real world.
To the real world.
And this is the part where I'm going to bow to your expertise.
Yes.
Because anytime we talk about current event stuff, at least, especially in this world,
you're always going to
have
the
upper hand on me.
Why, thank you. Let me adjust my crown. So, Kim Kardashian and Kanye West, as everyone knows, unless they've been living under a rock, I don't know, maybe.
I do know this.
Okay, I was about to say, Austin, before I start saying these things, they're not fighting words, but.
Right.
Anyway, they filed for divorce, or Kim Kardashian-West filed for divorce from Kanye. and they have 4 children, right? You know, you've got, hold on, let me see if I can name them. You've got North, Saint, Chicago, and Psalm, and I believe in that order. And so there's 4 kids. And then there's a lot of property, but we won't even go into that. But, you know, everyone knows that Kanye has had a lot of mental health issues. I mean, look at his recent run for president when he was running under the birthday party, I think was his party affiliation.
Why not?
It's creative. You got to give them that.
What?
It's creative. You have to give him that.
Right?
100%.
Points. No one denies he's a creative genius.
True.
Anyway, but he suffers from, I believe, a pretty intense bipolar disorder. And so I'm interested in what your thoughts are, Ryan, on how mental health of one parent will affect the child custody division. You know, particularly in the Kardashian-West divorce, and then just as a general feeling.
Sure. So, obviously, I'm not licensed in California.
Yeah.
So, you know, truth be told, but let's just say that these people were here in Texas. So you have a few options, and I know that they do have these things in California as well. You can do what's called a custody evaluation. And so what a custody evaluation is it is a neutral third party, which is the custody evaluator. And that person can be appointed by the court, or he or she can be agreed to between the parties. That person then goes into far beyond what the court could actually hear as far as evidence goes. So these custody evaluators can talk with the parties. They can talk with psychologists. They can talk with therapists. They can talk with school teachers, you name it. And those custody evaluators can kind of go far into more details and rely on hearsay and go through to determine who, in fact, is the better primary caretaker. Now, the court doesn't necessarily have to use that recommendation, but that is one thing that people can do. And, you know, if you have these two fighting for custody here in Texas and both sides want it, some courts, not all courts, because some courts don't like custody evaluations, but some courts may say, all right, I'm going to appoint a custody evaluator. Y'all come back in, 6-8 months, however long the custody evaluation takes, and we'll see what the truth on this thing. So that is something to consider when we're talking about mental health issues.
And as part of that custody evaluation, sometimes there can be a mental health examination that goes in there too, right?
That's exactly right. So you can do a psychological evaluation as well. And oftentimes when one party wants the psych eval, the other party wants the psych eval because they say, well, I'm not going to get a psych eval. The other side's not going to get a psych eval. So everyone spends more money. But a psychological evaluation can be one of those aspects. So, I've got a couple cases that I've had where the custody evaluator doubles as a psychological evaluator as well, and they go through and they not only do the custody eval, but they do the psych evals on both parties. So that can be something that is done. And then depending on the results of those psychological examinations and evaluations, the court can absolutely take that into account. So, it's something to think about. Now, when you're on the other side, and let's say a custody evaluation comes back for your client that's not good, then you can look into breaking up that psychological evaluation and saying, well, what did this person do that was incorrect, or what did they not do? Mm-hmm. And that's where, it's important to be able to understand those psychological evaluations so you can go in there and say, hey, they didn't do this, and this. How can we possibly rely on this thing? So,
yeah, and I'm glad you brought that up, Ryan, because we a lot of times in our world, in the family law world, you hear about, okay, well, the custody evaluator concluded this, the psych evaluator concluded this, but just like you were saying, they're still subject to cross-examination. It's not just that they're the be-all, end-all. It's just that it's a different tool that's used in this arena to try and get to that, well, to aid the court in making their final decision.
So you can still
right.
have...
Sorry. Go ahead, Andrea.
I was just going to say, so you can still have a battle of the experts in this setting, it sounds like.
Absolutely. So, and I will say that it goes beyond just psychological evaluations. I'm talking about any neutral experts. I've had cases where CPS comes in there and CPS says, dad is abusing this child. Well, okay. You put that person on the stand and then you figure out that they didn't make any phone calls to any, schools or anything like that, that they are basically basing this solely on the word of one party who is an interested party. These neutral experts can be cross-examined, and there's ways to absolutely kind of take apart what their recommendations are, because like you said, Austin, they're subject to cross-examination, and just because they're saying something doesn't necessarily mean it's true. I mean, I had in the case where CPS had claimed my client had abused this child, that it turned out that was a false allegation, and the court, the judge in that case, absolutely just admonished CPS and the other side for basically manufacturing a claim of abuse. And she said something that I'll never forget. She said, one of the worst things in the world is child abuse, but what's even worse than that is making a false allegation. And that resonated. So
yeah, absolutely.
I can imagine.
Yeah, absolutely. Well, so shifting to another current event story, something that's a little nuanced that we don't talk about a lot because it's kind of not weird, but it's just it's a unique area where there's a lot of gray areas, grandparents' rights.
Yes.
And I know this factors in a little bit into the recent royal family situation going on.
The royals. Who doesn't love the royals? Or maybe they all hate them now because, the crown and the Prince Harry and Meghan Markle interview that just occurred. I know Ryan watched it.
I did. My wife and I watched it, and it was kind of captivating. I won't lie. I don't know anything. I don't know anything about the royals. Everything that I know about the royals is told to me by my wife. Mm-hmm. But I think it was a pretty interesting thing. I mean, Meghan Markle has just single-handedly taken down centuries of a monarchy.
Right? I mean, power.
And you put it that way, yeah.
Loving it.
She was a paralegal on Suits.
From paralegal to princess, what better promotion can you get?
I mean, my gosh, it's crazy. But yeah, I mean, we were talking earlier. Mm-hmm. I mean, some of the things that were told to them were pretty horrific stuff about, about what color is your child going to be. I mean, that sort of thing
is my mind.
I mean, my gosh, but yeah, it's, that was a pretty expose sort of deal.
It got raw at some points. And so, so here is this family, right? And they've got their own twisted issues, and, Meghan has soldiered through it while being pregnant, right? Twice. And she's on baby number 2 now. They're expecting a little girl. So super excited. Like, as if I knew them. I don't. I wish I did.
I was going to let you run with that one.
Thanks. Yeah. Like, I don't personally know them. I've only seen them on TV. But, one of the things I thought was interesting is that you have the queen. So I guess Archie's, great-grandma? Yeah, great-grandma. And she's this, powerful central figure, and just everything revolves around the queen and what the queen says or does. So she has a lot of power in this family dynamic. And I thought that was kind of an interesting jumping off point to discuss what rights do grandparents have. And now, of course, the queen probably has, a little bit more help than, Granny down the street.
Yeah.
But I wanted to ask you, Ryan, what rights do grandparents have? And does it depend on the scenario that the particular couple finds themselves in?
Absolutely. I mean, generally in family law, everything is pretty case specific. Mm-hmm. So, whether it's modification, whether it's original suit, I mean, everything's pretty case specific. Now, over the last couple years, there have been two landmark cases in the Texas Supreme Court that have dealt with grandparents standing, which standing for listeners is when can you be part of a lawsuit, essentially. The first one was in 2019, and that case basically said that if you have actual care, control, and possession, and that's part of the statute. Let me back up a little bit. The statute specifies that if you have actual care, control, and possession of a child for at least 6 months, then you have standing in a lawsuit. That Supreme Court case, and it was the Texas Supreme Court, that case specified that you did not have to be the only one to have that care, control, and possession. So what I mean by that is, let's say the grandparents were taking the child to the doctor, they were taking the child to school, but mom helped out as well. The Texas Supreme Court specified that's okay. Grandparents still have standing to enter the lawsuit on this. Now, there was a more recent case that came out, it was about 6 months or so ago, and that case specified that no matter what that aspect of care, control, possession is, that the grandparents still have to show that there is some sort of significant impairment when it comes to, in this scenario, let's just say Meghan and Harry, that they are somehow significantly impairing the child's physical health or emotional development, something like that, and so that the grandparents have to prove that. The issue that comes up, though, is now you've got that grandparents can enter a case, and sometimes they're going to have more resources. So, in this scenario, the Queen probably has unlimited resources. Now, I'm not going to say that Meghan and Harry are panhandling these days, but and did I lose you guys there?
No, we're here.
We're here.
My screen is.
He's frozen.
Sorry, you guys there?
Yes, we are.
You got us, Ryan?
Okay. Sorry, my screen's freezing over here, so I didn't know. I think I was just talking to myself at some point there.
That's all right. Matt can edit that part, so you can just pick back up kind of where you were going.
Okay, so when you're talking about resources, sometimes grandparents will have more resources than parents, and that becomes an issue. And like I said earlier, when you're dealing with attorney's fees, it's pretty damn hard to get them in SAPSR cases unless it's a divorce. So those are things to consider, but grandparents do have rights. They are just, right now, the Texas Supreme Court is still working on those, defining those rights, but the statute specifies that they have standing. It's just exactly where they can go with that standing that has been curtailed a little bit by the recent case that just came out.
Awesome.
Interesting. Yeah. Good to know.
Yeah, absolutely. It's a very nebulous kind of area of the law, but no, that was a great explanation, Ryan. So kind of as we wrap up here, just to recount for our listeners, you said that you're going into a modification, into a custody battle, you need to document everything. You need to keep your emotions in check, and you also need to be careful what you agreed to originally in the original order, because it's such a high burden. Ryan, we really appreciate you being here today, talking us through all this stuff and sharing some of your stories with us and some of the drama that comes in our wild world of family law.
No, it was great to have you guys. Great to have me on, rather. I guess I'm not having you guys.
Well, you're having us on your screen. It's a screen share.
This is your show, not mine. So thanks for having me on. No, I appreciate it. If any of the listeners want to follow me on social media, my Twitter handle is @TheLegalSegall. That's SEGALL. My law firm is Walters Gilbreth, GILBREATH, like a breath, and so WaltersGilbreth.com. We practice all over the state. We have offices in Austin, Houston, and Dallas. So, wherever you are, we're there to help. But I appreciate you guys having me on and being able to talk about these things, because everyone always likes to talk about family law, right?
Exactly. Well, Ryan, thanks again, and thank you all for listening. Stay tuned for closing arguments. We're going to put a cap on the finality of President Trump's election challenges.
Oh my goodness. Hey y'all, don't go. We have closing arguments coming up for you in just a second. But before you listen, make sure to rate, review, and subscribe to the podcast if you got any value from today's episode. And please share the podcast with others. And if you want to interact with Austin or me, or tell us what you want to hear next, you can find me on Instagram at andrea.s.turner, Austin at the Dallas Lawyer spelled out, or the podcast #lawyered spelled out. Look forward to hearing from you.
On March 8th, the U.S. Supreme Court put an end to President Trump's last stand on election fraud. President Trump originally challenged the election on the basis of fraud with 42 different lawsuits lodged in 7 states: Pennsylvania, Nevada, Georgia, Wisconsin, Arizona, Michigan, and New Mexico, and 3 petitions directly to the Supreme Court. Losing at the trial court level on every claim except for one in Pennsylvania, which was eventually overturned by the Pennsylvania Supreme Court, President Trump was denied relief at the Supreme Court level on March 8th in his last remaining state claim in Wisconsin, ironically by a Supreme Court including 3 Trump appointees. Despite that this issue is legally put to bed through our justice system, this turn of events has already prompted lawmakers to draft legislation aimed at curtailing these alleged issues in future elections.